Mobility Company in another, and Ericsson Ltd in another.
Yes.
May it please you, my lords, I appear with Ms. Pickard on behalf of the appellants, then friends Mr. Tappan KC, Ms. Davies KC, and Ms. Peterson appear on behalf of the respondents. I shall assume that my lords have read the judgment and skeleton arguments.
Yes, thank you.
And as I understand it, my lords now have the joint authorities in 4 bundles.
4 packed bundles.
4 packed bundles. Lords, there are a number of authorities raising a number of quite distinct areas of law, but at a level at which it may not be necessary to consider the details of those cases at great length. And indeed, as I understand it, since we only have a day for this appeal, it will not be possible in any event.
Yeah, thank you.
I shall refer to the appellants as Novo and the respondents as Ericsson. This court is all too familiar with both parties. Each of them owns a global portfolio of standard essential patents, in relation to which they've undertaken to the European Standard Setting Institute, which I shall call ETSI, to offer licenses to implementers of ETSI cellular telecommunications standards on FRAND, that is, fair, reasonable, and non-discriminatory terms. Each of them is an implementer of those standards, including in particular the standard in relation to 5G. Both of them at least avow that there should be a cross-license between them. As Lenovo sells smartphones and other such mobile devices to the public, and Ericsson sells products and services to network providers, whilst they are in the same space, they are not competing with one another for sales. If I may just outline the structure of the submissions that I propose to follow. First, I shall endeavour to identify some of the key facts found by the judge at first instance, and not, as I understand it, in dispute. It should not be necessary to refer to much, if any, of the evidence for the purposes of this hearing, although a considerable amount of evidence is collected in the supplemental bundle which my lords have. Secondly, I shall touch on what Ericsson describes as the bad actor issue, and say something about the undertakings that Lenovo has given to take an ETSI FRAND license, determined by the English court or the Federal Court of the Eastern District of North Carolina, the EDNC, as we shall refer to it, or indeed, as our lords will see from the pleadings, any court of competent jurisdiction. Third, I shall endeavour to explain how the issues of this appeal relate to some of the FRAND issues which have been occupying the court more generally, and I shall refer in due course in particular for the summary of the context in which these issues arise to the judgment of my Lord Justice Arnold in cellular technology and Apple, which should be in your authorities bundle, JA4 tab 32. Fourth, I shall address the grounds of appeal individually. I will, of course, there be traversing essentially the same ground as that covered in our skeleton argument, though I shall endeavour to focus on the points raised by my learned friends in their skeleton argument. And then briefly, I shall endeavour, or perhaps it would be more accurate to say, be unable to resist standing back and addressing the matter by way of conclusion in the round. So, my lords, First, the facts as found by the learned judge below. The Lords will find her judgment in the core bundle behind tab 7 at page 71. We note first at paragraph 14 that it is common ground that insofar as the parties' FRAND undertakings are invoked, any FRAND license will be a cross-license. Secondly, one goes to paragraph 20, and the last 4 lines there, she says, "It is not seriously disputed that the injunctions obtained by Ericsson," that's the injunctions obtained in Brazil and Colombia, that Ericsson has pursued, that the injunctions obtained by Ericsson are causing and will cause very significant disruption to Lenovo's business in markets that are very important to it in commercial terms. So whilst there may be an issue as to the circumstances in which regard may be had to that disruption, there is no issue, we would submit, as to its gravity. In paragraph 21, at the beginning of that paragraph, she goes on to state, "It is moreover implicit in Ericsson's evidence in these proceedings that Ericsson has pursued the proceedings in Brazil and Colombia as a means of exerting commercial pressure on Lenovo to reach agreement with it on the terms of a global FRAND license." And we submit that that is, again, not seriously in dispute. There may be an issue as to whether or not it is conduct which is to be deprecated or not. Fourthly, we note at 35 of the learned judge's judgment on page 78 of the bundle that she states in the last 4 lines, "If the injunctions in those countries are maintained, I accept there is likely to be significant disruption to Lenovo's business and strategy, both in the short term and in terms of Lenovo's longer term ability to grow and retain market share." That, I might say, simply emphasizes the consequence of the loss that she identifies in paragraph 21 of her judgment. And at paragraph 36, also of course on page 78, in the second half of that paragraph, she goes on to state, "The short and obvious point is that the maintenance of injunctions in markets which are of considerable commercial significance for Lenovo enables Ericsson to exert commercial leverage on Lenovo to take a license on the terms offered by Ericsson during the interim period before a FRAND rate is determined either in the EDMC proceedings or in one or other of the English proceedings." The one bit of evidence that I should take my lords to is the third witness statement, or is in the third witness statement of Thomas Foster, the partner with conduct of the proceedings on behalf of Ericsson. And one finds that in the supplemental bundle behind tab 16 at page 235. The relevant paragraph is paragraph 9, which is on page 237. He states there Ericsson's position. Ericsson's position is that relief of the kind sought by the preferred alternatives, that's the proviso to the order that we are seeking,
Yes.
would be extremely damaging, both in this case and in principle, because it would appear to allow any party that owes royalties to a SEP holder to effectively shut down worldwide infringement actions, thereby removing the licensee's incentive to negotiate a FRAND license prior to any FRAND rate settling by the English court. So what is being said there is that, as a matter of principle, it is wrong for an order to be made to protect the ability of the implementer who is committed to taking a FRAND license as determined by the court from getting such a court determination. If Ericsson succeeds in establishing that principle, if it succeeds in successfully resisting this appeal, if it gets its way, there will be no FRAND determination in this case, or at least there will be a serious risk of there being no FRAND determination in this case, either before the English court or the EDNC or any other court of competent jurisdiction. And if that is the way forward for Ericsson as a SEP holder, no doubt there will be others that follow the same course. My lords, there is a lot of evidence before, or was a lot of evidence before the judge at first instance, about the history of the negotiations between the parties and what each of them contended the rates should be. Lenovo is not asking the court to make any findings about those issues, and Lenovo's criticism of Ericsson's conduct does not depend on any findings about those issues. At paragraph 10 of its skeleton argument, which is in the core bundle behind tab 4 at page 46, Ericsson notes that Lenovo seeks to cast it as a bad actor, and some time is spent by Moylan and friends going through the history of the negotiations. However, that's not our criticism of Ericsson's conduct. The criticism that we make of Ericsson's conduct is that made by the judge herself at paragraph 37 of her judgment, which is in the core bundle behind tab 7 at page 78. As she states there is no doubt that the courts have deprecated the practice of bringing of infringement proceedings in multiple jurisdictions around the world as a way of exerting commercial pressure on alleged infringing implementers of SEPs to agree supra-FRAND terms. The judge was referring there in particular to the observations of Mr. Justice Mead in the Panasonic and Xiaomi case at paragraph 14 in the judgment, which is at JA3 tab 24, page 1112, I'm not sure it's necessary at this stage to go to that, but there is a very clear statement of, as it were, judicial frustration at the practice that the judge in this case has identified, a frustration which he refers to and reiterates in proceedings between these parties in the judgment at JA3 tab 23 1104 paragraph 13 on page 1107. It is no part of Lenovo's case that the pursuit of patent proceedings in multiple jurisdictions is illegitimate regardless of the circumstances. It's not part of Lenovo's case that the pursuit and enforcement of interim injunctive relief in multiple jurisdictions is illegitimate regardless of the circumstances. In this case, one party, Ericsson, is asserting its patents in Brazil, Colombia, and elsewhere to pressure Lenovo into agreeing a cross-license before Lenovo has a chance to obtain a court determination of what the terms of a FRAND cross-license should be. There is a slight complication in this case, to which I have already alluded. The court which will determine the terms of a FRAND license in this case could be this court, or at least in theory, the EDNC. However, we shall endeavour to show that that does not provide Ericsson with any justification for what we describe in our skeleton argument as its strategy. Its attempt by bringing multiple proceedings for interim injunctive relief in other jurisdictions to coerce Lenovo into making an agreement which it would not otherwise make, and depriving Lenovo of the benefit of a court determination. As far as the undertakings given by Lenovo itself are concerned, the judge refers to that in her judgment at paragraph 24. She notes that Lenovo's undertaking is set out in the particulars of claim, and it is that it will enter into a license agreement in the form that is determined to be FRAND at the FRAND trial in these proceedings, or to the extent that there are any appeals, a license agreement that is finally determined to be FRAND on appeal. She might also have referred to the way that the matter is put in the particulars of claim at paragraphs 20 and 21, which one finds in the core bundle behind tab 11 at page 96. I don't think...
Can we look at that? So, core bundle...
tab 11, page 96.
'20 and 21.
It's 20 and 21. 20 setting out the undertaking which we say has been refused by Ericsson, and 21 setting out Lenovo's undertaking to give the equivalent undertaking
In the event that Ericsson
and
provides the undertaking as
above.
above.
Yes.
So you've offered to undertake, but only if Ericsson undertakes. But there is, as I understand it, and please correct me if I've misunderstood, no unequivocal undertaking by your clients.
My lord, before answering the question, I should go to draw an ordinance attention to what is stated in paragraph 15. That, we say, is an unequivocal undertaking. What is not, as my lord puts it, an unequivocal undertaking is the commitment in paragraphs 20 and 21, which my lord will have seen is expressed conditionally. But in saying it's unequivocal, I may be doing my client an injustice. The commitment is in no way unequivocal. The undertaking is given there in the pleading. It is conditional in the sense that what then occurs, the giving of the equivalent undertaking to Ericsson, only follows in the event that Ericsson has given that undertaking. But, my lord, I would make two observations about this. One is as to the nature of such criticism, if any, which has been made of the adequacy of the undertaking, and two, as to the purpose for which I am relying on it. We will see that no substantial criticism is made of the adequacy of the undertaking, and I take the Lord to the points made by my learned friends in relation to it. But secondly, whilst there may be more than one way of expressing such an undertaking, the critical question will be whether or not what we have done is sufficient to render us a willing licensee. Because provided that what we have done is sufficient to render us a willing licensee, one proceeds to the next question, which is what in those circumstances are Ericsson's obligations pursuant to its ETSI undertaking towards us. So precisely how one characterizes that undertaking is, we will submit, not ultimately going to be a matter of any substance.
Could I ask one thing? I understand entirely you refer to expressions of judicial frustration, for whatever those are worth. But you say that what Ericsson has done, you use the words illegitimate and unjustified. And I'm wondering against what standard or law one judges such illegitimacy, where we don't normally criticise the acts of courts of foreign courts of competent jurisdiction as illegitimate. Basic principles of comity, well-travelled areas in the area of anti-suit injunctions. How can one say that what's happened in Brazil and Colombia is in any way illegitimate? Aren't those arguments to be had in Brazil and Colombia, if anywhere?
My lord, it is no part of our case before my lord that what has been determined by the courts in Brazil and Colombia was not in accordance with their laws, or it's a form of relief which may be legitimately open to the proprietor of the patents that they have there, subject to two things. First, the contractual derogation from their patent rights generally, pursuant to the ETSI undertaking. And secondly, the use that they are seeking to make of rights which they might otherwise legitimately exercise in other circumstances, in other jurisdictions, to deprive us of a hearing, either here or in the ETSI.
If what they have done in Brazil and Colombia is a breach of rights which you have, which are enforceable in this jurisdiction, then you can obtain an anti-suit injunction.
Lord, first of all, I may need to distinguish at some stage between what is enforceable and what is specifically enforceable. And there is a French law issue as to that in relation to the ETSI undertaking, which I'm not in a position to advance an argument on today. Secondly, though, we would submit that when it comes to the grant of injunctive relief and the exercise of the court's discretion in relation to that, it is legitimate to have regard to whether the mischief which the order is directed to is one that involves a breach of contract, whether or not the cause of action is itself founded in breach of contract, because the disregard of one's contractual obligations is a mode of conduct which, when exercising an equitable jurisdiction, the court may consider. And secondly, that if and insofar as this mischief is directed, as it appears expressly to be directed, to depriving us of a court hearing before this court, it has much of the character of an anti-suit, even if it is not framed as an anti-suit, in the sense that it is conduct which this court would regard as unconscionable, and conduct of a kind which threatens the efficacy of the court process. I'm saying that it has much of the character of an anti-suit. What I mean is that it is conduct which this court would judge as unconscionable, and as unconscionable conduct of a kind which this court will, where appropriate, restrain. But in other respects, it has none of the characteristics of an anti-suit. It does not require a party to withdraw proceedings. It does not require a party to even stop pursuing injunctive relief on an interim basis in any foreign jurisdiction. It does not advise a foreign court as to the law. What it does, when one takes into account the proviso, is influence the party to whom it's directed in a way which may affect what they do in.
Well, aren't you really saying that you want there to be three wrongs making a right?
No, my lord, but there is, we would say, no tit for tat here, and I will come to why I say that. And I will also develop, perhaps at a later stage, in giving a more complete answer to my Lord Justice Phillips, the case for saying that the nature of the influence which we are seeking to bring to bear in obtaining this order is in no way one that should concern the court. It is inherent in the FRAND order that the Supreme Court in Unwired Planet has itself fashioned. The issue here arises because one has a number of territorially limited rights, UK and other foreign patterns. One has a global industry, and one has that global industry operating to standards which the implementers and the SEP holders accept should be governed by certain principles and undertakings as given to organizations such as ETSI. And what the Supreme Court does in the Unwired case is say, albeit at that stage in relation to a permanent injunction, following the determination of the validity of a UK patent, that you will be enjoined unless you enter into a global license. The whole structure of that, injunction plus proviso requiring a global license, will influence conduct in other countries. It may well lead to proceedings in other countries being abandoned because of the commercial pressure brought to bear on the implementer by being put to an election. Either you withdraw from the United Kingdom or you sign up to a license which will govern your conduct across the globe. So yes, it does influence the parties, but in a way which has been sanctioned by the Supreme Court.
Can't exactly the same thing be said about Brazil and Colombia?
My Lord, that's the tit for tat issue. And the critical question there, to which I will come, is the circumstances in which it is legitimate and the circumstances in which it is illegitimate to bring such pressure to bear. And in relation to that, I will seek to show that the ETSI regime, as explained by the Supreme Court in the Unwired Planet case, and also by my Lord Justice Arnold in the Optis and Apple trial F case, makes it clear in what circumstances it is legitimate and in what circumstances it is illegitimate to do what Ericsson is doing. The critical difference between the parties being that Lenovo has committed to take a license, and Ericsson is using its commercial power to oblige Lenovo, if it is able, to accept its terms before there is a possibility of the court determining what the terms of a FRAND license should be. I should perhaps, my Lord, just pick up two brief points in relation to undertakings and the
given the time pressures, I don't want you to be distracted from the course of your submissions and take points. I think it's better that we wait until you deal with the points in the order that you want to deal with them, as I say, given the time pressure. But do take those additional 2 points if you want to.
That's kind of, Lord. I was, in fact, just going to note, in relation to the English proceedings for a FRAND determination, and in relation to the EDNC proceedings, the timing of the two trials in those cases probably makes it academic, whether one focuses on the undertaking given in relation to the UK or the wider undertaking. I'm instructed that the trial of the English FRAND proceedings is listed to commence in a window between the 29th of April next year and the 2nd of May. And the judge notes at paragraph 17 of her judgment, so that's core bundle tab 7, page 74, that for various reasons, the EDNC proceedings are unlikely to come to trial before late 2026. The point she notes reflects the conclusion which Mr. Justice Richards summarizes in his judgment in the English proceedings at paragraph 55, which for present purposes I will just refer to. That is Joint Authorities Bundle 4, tab 27, page 1432. Ericsson's position may be there's nothing wrong with a party using the disruption it may cause to another party's business to deprive the other party of the benefit of a court determination of the terms of a FRAND license, regardless of the other party's commitment to accept such a license. We shall endeavour to show that that's wrong. They say at paragraph 18 of their skeleton argument, so that's Core Bundle tab 4, page 53, that it is important to note that Lenovo is not committed to accept whatever rate the EDNC may determine. Ericsson appears to be saying that it's entitled to choose the jurisdiction in which the FRAND dispute is resolved, as well as we shall see, in the manner in which the court resolves it. There are a couple of points here which we can probably put to bed. Before Mr. Justice Richards, on the directions and jurisdiction challenges, Ericsson argued that it was entitled to choose the jurisdiction because it would be the net payee under any cross-license. Lenovo did not and does not accept that the net payee is entitled to choose the jurisdiction regardless of all other circumstances which might make one jurisdiction more appropriate than another, and of course it doesn't accept that it will be at the net payor. However, we say this is not something that this court can resolve, and indeed, in his judgment at paragraph 54 in the Joint Authorities Bundle 4, tab 27, page 1431, Mr. Justice Richards noted that it was not a dispute which, on the evidence before him, could be resolved at this stage. And of course, the court has dismissed Ericsson's challenge to this court's exercising jurisdiction to determine the terms of a cross-license. Now, I come then to the judge's reasons for dismissing the application at first instance. The judge dismissed Lenovo's application on the basis that Ericsson's infringement of the patent in suit, EP 649 as we refer to it, would not cause Lenovo any loss which would not be adequately compensated by an award of damages, and the loss which Lenovo is seeking to avoid is not one which Lenovo can rely on in relation to the infringement of that patent. It is Lenovo's case that the judge took too narrow a view of the loss that may be caused by the infringement of the UK patent, that she took too narrow a view as to how the damages for the infringement of a UK patent may be calculated in accordance with the principles explained by the Supreme Court in the Morris Garner and One Step case, and that she failed to take proper account of the fact that the loss would include at least a loss of the FRAND royalties payable in respect of EP 649. I said, I think, the FRAND royalties, some part of the FRAND royalties that would, in any cross-license on FRAND terms, be attributable or notionally attributable to the right to practice that particular fact pattern raised by this case is a novel one. However, we'll seek to show that this application falls squarely within the principles enunciated by the Privy Council and the Supreme Court in the recent Broad Idea and Wolverhampton cases, and that it is perfectly consistent with the approach set by Lord Diplock in the American Cyanamid case, as is explained in the more recent authorities relating to the exercise of the Section 37(1) jurisdiction. Lords, before dealing with specific grounds, I should say something further about the ETSI context. This application is based on a claim of patent infringement. However, the application is not, whilst the application is not based on the ETSI undertaking, an understanding of the ETSI undertaking and the ETSI regime and the way in which Ericsson is violating that regime and disregarding its undertaking is, we say, of relevance when it comes to asking whether it's just that Lenovo should be left to its remedy in damages, praising the way in which the matter is put by, I think, Lord Justice Sachs in the Bertola Sherry case. So I come on to the question how the regime is supposed to work, and would refer first of all to three passages from the judgment of the Supreme Court in the Unwired Planet case, which is to be found in JA2 behind tab 19 at page 642. The first passage is paragraph 61 on page 663, some 5 or 6 lines into that paragraph, referring to the ETSI IPR policy. The Lordship said, the IPR policy encourages parties to reach agreement on the terms of a license and avoid litigation which might involve injunctions that would exclude an implementer from a national market, thereby undermining the effect of what is intended to be an international standard. One moves forward to paragraph 62, and the top of page 664 of the bundle. They say there, the IPR policy envisages that courts may determine whether or not the terms of an offered license are FRAND when they are asked to rule upon the contractual obligation of a SEP owner, which has made the irrevocable undertaking required under the IPR policy. And at paragraph 64 on the same page, beginning of that paragraph, we agree with the parties that the FRAND obligation in the IPR policy extends to the fairness of the process by which the parties negotiate a license. From those observations of the Supreme Court, we would say that it is clear, one, that the ETSI undertaking to offer a license imports an obligation to negotiate fairly and reasonably. Two, that the court determination may be part of the process by which the parties arrive at the terms of a FRAND license. And three, the parties should look to resolve their differences in a way which does not involve market disruption. To those conditions or observations, we would seek to add others based on three passages from the judgment of my Lord Justice Arnold in the Optus and Apple case. That is at Joint Authorities Bundle 4 behind tab 32. The case is concerned with what's required of an implementer in order to avoid being restrained by injunction prior to the determination of the terms of a FRAND license by the court. The context in which the issues in the Optus case arose are set out in the general background section, that is the legal context, which is in paragraphs 4 to 15. The specific paragraphs to which I wish to draw attention are further on in the judgment, starting with paragraph 73, and I'm afraid that at least in my version those pages are not paginated in the bundle. It's at page 24 of the report. Page 24 of the report, paragraph 73, about 10 lines down. The present issue arises, however, when the parties cannot agree terms. In those circumstances, the National Court must resolve the dispute, as paragraph 4.3 of the ETSI Guide states, and as both the CJEU and the Supreme Court recognise. And then at paragraph 87, at the bottom of page 27 of the report, the fact that the undertaking is irrevocable suggests that it should be open to an implementer to enforce it at any time, regardless of whether the implementer has previously decided not to do so. And finally, paragraph 91 on page 28 of the bundle, there is a very real likelihood, I'm reading there from the bottom of that paragraph, there's a very real likelihood of Apple accepting the court-determined license at least once the parties' rights of appeal have been exhausted, and hence being entitled to enforce the ETSI undertaking. From these three passages from our Lord Justice Arnold's judgment in Optus and Apple, we derive the position that an implementer who makes a commitment to take a license determined by the court is to be treated as a willing licensee. And if we take the observations of the Supreme Court in the Unwired Planet case, together with those of the Court of Appeal in the Optus and Apple case, we may conclude that where an implementer has given a commitment to take a court-determined license, the set holder should not be seeking to disrupt the implementer's business by seeking injunctions anywhere which will be covered by that license. The fact that the rights which the set holder might exercise afford it the opportunity to seek to disrupt the set holder's business, the implementer's business, does not render it legitimate from the perspective of the ETSI regime, which, as the Supreme Court observed at paragraph 14 in the Unwired Planet case, That's at JA2, tab 19, page 650. And it's the second of the points that they state there. The SEP owner's undertaking, which the implementer can enforce to grant a license to an implementer on FRAND terms, is a contractual derogation from a SEP owner's rights under the general law to obtain an injunction to prevent infringement of its patents. So we say that the deprecation of the sort of practice which Ericsson is up to here by Justice Mead and others is not simply an expression of judicial frustration, but well founded in a understanding of the way in which those who have given undertakings are obliged to behave. And it's important to distinguish here two things. First, the focus of this analysis, namely Ericsson's subsisting agreement to permit the infringement of its SEPs pending the court determination of the terms of the FRAND license which Lenovo is committed to take. That's the focus. The focus is on whether they are already committed to permitting it. And the second, which is a separate issue, the terms on which Ericsson might grant Lenovo an interim license to practice Ericsson's SEPs pending the court determination of the commercial terms which should ultimately cover such practice. The ETSI undertaking is enforceable by any willing licensee on the licensee satisfying the conditions of being or to be a willing licensee. There is nothing further that Ericsson may do or refrain from doing before it is bound by that. The ETSI undertaking may or may not entitle an implementer to the SEP holder's consent to practice its SEPs pending the court determination of the commercial terms which will apply, but that is a separate issue. I should introduce just one caveat. There may well be circumstances in which a SEP holder could not fairly or reasonably refuse to offer an implementer a license to cover the period of proceedings in which the court is to determine the terms of a FRAND license for other reasons. This is not an exhaustive account. The critical point is that once we have committed to take a license, then the SEP owner's obligation, Ericsson's obligation, it's a subsisting obligation, and it applies. Now,
could I ask this? As I understand, the proposition you've drawn from these authorities is that where the implementer has given an undertaking to accept the license, the holder should not disrupt the implementer's use of the patented invention in the meantime. Is that said anywhere in any of the authorities?
My Lord, it is what I seek to draw by way of conclusion from the passages to which I have taken, my Lord.
Yes, but I've been trying to find out where. I can't draw it from anywhere. And as I understand these authorities, they're talking about the commercial reality of the way that the process works by whether or not the court grants an injunction or not. I don't see here, in fact, any of the propositions that you've put forward are actually articulated in any of the authorities. I may have missed it, but I didn't see,
Well, my Lord,
for example, the reference to a duty to negotiate fairly. Where can I find that?
well, my Lord, if I go back to the passages from the Supreme Court in the first instance, on which I seek to rely on.
Was
What
bundle
we
two.
submit that they show, we started, I think, with paragraph 61, which is concerned with if I just step back a moment, we're concerned with the effect of the undertaking which is given by both parties in this case to not only ETSI as an institution, but all those implementers who might require a license. And what the Supreme Court does in its analysis of the policy and in the way in which it is supposed to work is identify the fact that the undertaking isn't simply to offer a license, but to engage in a process.
Yes, well, on that, I'm afraid to say I'm bound to observe that although the parties have given us 4 full bundles of authorities, many of which are of dubious relevance, what you haven't put in is this court's latest judgment on the subject in Digital and Lenovo, where the point is made very clearly that FRAND is not an endpoint, it is not just an endpoint, it is a process.
My Lord, I apologise for not including that, but I'm grateful for my Lord's observation as to what he said
You
there.
can take it as read that certainly for my part, and the court as a whole accepted it in that case. FRAND is a process. However, the question is, what is the implications of that?
My Lord, yes. And what we submit, and, well, if it is a process, and by FRAND one means the working out of the implications of the undertaking that the patentee gives to ETSI, then it is a process which the patentee is obliged to follow at risk of being in breach of its undertaking. And one therefore looks to see what the substance of that process is. And from both the decision in the Unwired Plunder case and in the Optus and Apple case, and as I am correctly reminded with respect by my Lord Justice Arnold, in the most recent decision of the Court of Appeal on this subject, the process requires the parties to conduct themselves in a particular way. So all I need to do for the purposes of this case in relation to the ETSI undertaking is endeavour to show that the conduct at issue in this case is contrary to the norm. And we would say it is plainly contrary to the norm, given that it is not only deliberately disruptive in circumstances in which Lenovo is to be treated as a willing licensee, but because the disruption is not only gravely damaging to Lenovo's business, but doing something which the court generally deprecates, which is that it is calculated to deprive a party of a determination of the dispute between the parties.
Well, that's the point at which you're going to have to come back to and persuade us, because the authorities certainly go so far as to say that FRAND is a process, and therefore the set holder must conduct itself consistent with its obligation to grant a license on FRAND terms and not to engage in hold-up, and likewise the implementer must likewise behave in a way that is consistent taking a licence on FRAND terms and not engaging in hold-out. However, the question, obviously, in this case, is whether it follows from that that it is inconsistent with that for a party to engage in litigation in more than one jurisdiction.
My Lord, if by follows, the question is it necessarily the case? We do not need to go that far. What we need to identify is certain general characteristics of this case, which, absent special circumstances, are sufficient for our purposes. It is always difficult when seeking to judge these matters on an interim basis to determine the rights and wrongs at a level of specificity. And that can be used by a party which is seeking to commit and continue its wrongs. And it says, well, you can't determine this on an interim basis. But our submission is that, in fact, on the facts of this case, you can determine it on an interim basis because it is screamingly obvious that what they're doing is wrongful in the sense that it is in breach of the ETSI undertaking. And we say that that is clear and obvious, given that their that their motive is to oblige de novo to enter into an agreement on their terms under threat of commercial pressure rather than obtain a court determination, and that is inherently contrary to the regime as characterised by their lordships in Unwired Planet and by this court in the Apple and Optus case. One doesn't need to know any more about this case.
Well, again, we're going to have to come back to that, because the question is whether that necessarily follows. Because, of course, as I think you're bound to accept, having regard to the passages from Unwired Planet you cited, the system is predicated on parties' first resort being to negotiation and agreement. Litigation is a last resort. So it will be said against you, in principle, that there is nothing wrong with seeking to persuade an opponent to enter into an agreement. On the contrary, it's what parties should be doing. The question then is, well, does it make any difference if there's a commitment to accept a court determination? And of course, one of the factors that bears upon that question, which David has touched on yet, is the fact that FRAND is not a single point, it's a range. So we have to bear that in mind as well.
My Lord, first of all, dealing with the there is a period of time on which we are focusing, and that's the period after which there have been substantial negotiations, and there is at least one, but in this case more than one case, but court, seized of the issue between the parties. Now, there is a subsidiary issue as to whether the EDNC will actually determine the terms of a FRAND license if it ever gets there, or simply determine whether Ericsson's conduct was itself in compliance with its undertakings at the stage at which it offered what it did. But
is that relevant?
I was going to say,
because on the timings, this jurisdiction is going to decide first.
my Lord, that is only relevant if one comes to my Lord's second question in relation to the range. And my Lord will be all too aware that there are jurisdictions in which the focus in relation to FRAND matters is more directed to Article 102 and competition issues, and there are others in which it may be directed to the determination of what the appropriate figure should be. Those are issues which do not fall to be resolved in this case. They're issues which can properly be resolved in the proceedings which the parties are already committed to. One doesn't need at this stage to resolve every outstanding theoretical or metaphysical issue in relation to the proper conduct of the FRAND regime. The question one needs to ask oneself is, given the commitment to court proceedings that Lenovo has made, given that Ericsson is properly before the court, and that this court will determine the terms of a FRAND license, if it is permitted to do so and we're not forced to withdraw, what is the proper way in which a party in those circumstances of Ericsson should act? It may be that in those FRAND proceedings, Ericsson will take a point that the rate which is determined to be FRAND by the English court is not one that it's obliged to actually offer. But that's a matter which is to be determined if raised. It's a bad point, we say, of course, but it's a matter which is to be determined if raised in the proceedings. The question is, does a party which has granted has entered into an ETSI undertaking and committed to a regime which should avoid disruption of the market where reasonably and fairly possible, where there are already proceedings afoot and the counterparty is committed to take the product of those proceedings, a court-determined FRAND license, in those circumstances, how should the set holder act? And I can't point the Lords to an answer to this question in the authorities, because of course that's why we're before my Lords in part. But I would submit that it is, or should be clear and obvious, that any conduct which is calculated to disrupt the market, cause unnecessary injury and deprive a party of a court-determined license, is to be deprecated, and that if it is conduct of a kind which is acceptable, the whole unwired planet ETSI framework is in danger of unraveling, because court proceedings inevitably take some time. There are jurisdictions in which, for whatever reason, it is possible to obtain interim injunctions and gravely disrupt a implementer's business, while proceedings in this country or other countries which will determine the terms of a FRAND license are continuing.
Yeah, well, that takes me to my next question, because as I understand it, you have an application for the Patents Court in October for an interim license, an interim cross license. Suppose Patents Court accedes to that application and makes an order for an interim license. Is that not an answer to your problem?
Lord, if the Patent Court accedes to the application and makes an order for an interim license, and we therefore have an interim license which can be taken to other jurisdictions or itself enforced in other way so as to ensure that the mischief of which we complain ceases, it will be an answer to our problems. But Lord, I'm not sure that's yet been decided in our favour. and the fact that there is an alternative way in which one may obtain such an answer does not mean that this is not a way that is also available to us and should be. I should, in fairness, though, acknowledge that I may have indulged in some hyperbole in saying that the system will unravel if the order that we seek in this case on these terms is not granted. I'm not sure I put it quite that way. One way or another, there needs to be a means of preventing SEP holders frustrating the determination of FRAND terms by the courts and by imposing pressure in the market on implementers, obliging them to enter into licenses which will then never be the subject of scrutiny. This may not be the only way. It is, of course, not my case that it is the only way. But there needs to be a way, and we say, on the facts of this case, this is a particular way. It depends, of course, on the fact that Lenovo is not only an implementer, it is also the owner of its own portfolio. And of course, we observe that one of the principal values, potential values, of being a portfolio owner in this context is that the patents may be used as a deterrent as well as simply as a potential revenue source. It may not apply in all cases, but it is, we say, a proper way of seeking to exploit the patent in this case.
Could I just ask, as I understand it, you're seeking to persuade us that Ericsson's conduct is wrongful, or at least, as you say, out of the norm, and therefore justifies an injunction. Of course, you're not seeking to restrain that conduct, are you?
My Lord, I balked slightly at the end, therefore justifies an injunction.
Well,
the injunction is sought on the basis that there is a serious issue to be tried as to whether there's an infringement. We are concerned with a patent right, proprietary right, the violation of which is normally attracts as a remedy injunctive relief. The question is, what considerations may be taken into account when considering the justice of granting relief on an interim basis in any particular case. The foundation of the claim is patent infringement, but we say when the court gets to consider, in a case where there is a serious issue to be tried as to the cause of action itself, whether to grant injunctive relief, it is legitimate to take into account that the mischief to which the order is directed is itself unlawful, in the sense that it's in breach of contract, or certainly strongly arguably so, and unconscionable, both because of that and because of its object, which is to frustrate the judicial process.
but that has nothing to do with the infringement you're seeking to injunct.
Well, I'm going to endeavour to go on to show that that's not the case. It is a separate, I mean, the focus is separate, but whether or not it has nothing to do with it is a separate matter. What we are seeking to injunct is the practice of our patent for a particular purpose and in breach of an undertaking. and we say it is legitimate for the court, whether one wants to characterize it in terms of common sense or however, to see the mischief in those terms and to be willing to grant an interim order on the balance of convenience or the balance of justice in those circumstances, even if it would not ordinarily grant such an order.
What you say is that
case.
the court should grant an injunction that it wouldn't grant purely in relation to this infringement, in order to give you leverage in relation to the infringement of other patents. That's the argument.
My Lord is anticipating some of the issues which I need to address when one comes to the specific
Yes.
grounds. It rather depends what you mean by this infringement.
Yeah, well, I agree with you that we need to focus on your grounds soon. But just before we do, just so as we're all clear, can we have a look at the order that you're actually asking for, which is supplemental under tab 5. So, it's paragraph 1, restraining the defendants from disposing, offering for sale, disposal, etc., equipment or software that operates in accordance with the relevant 5G ETSI specs, which are listed. And then there's any other process which falls within the claims of EP 4649, and one can debate whether that's appropriate having regard to state and digitext, but let's ignore that for the moment. But what that tells us is that this is an injunction to restrain alleged acts of patent infringement on the basis that the patent in question is essential to the 5G standard.
Yes.
And then we get into paragraph 2, which is it doesn't apply if certain things happen. And what you really want is for one of those things to happen. You don't really want paragraph 1 at all.
My Lord, that's absolutely true, but that is the same in relation to most FRAND cases, and a standard FRAND injunction in accordance with the decision of the Supreme Court in the Unwired Planet case. What the SEP holder wants is a global license, not an injunction. So there's nothing inappropriate about our objective here. Indeed, one might wonder why anyone should simply want to spoil other people's practice of the standards. One focuses on paragraph 1 without the benefit of the proviso in paragraph 2. Where one has an order which includes a proviso, one must construe the order, including the proviso, as a whole, and the objective of the two together is an entirely proper one. Does that answer my Lord's question, if there was one?
Thank you.
I come then to the grounds. And, I don't know if Lords were anticipating rising at any stage or not. So far as ground 1 is concerned, we say that the judge failed to address or accept Lenovo's case, that if the order was not granted, Lenovo might be forced by the coercive pressure of Ericsson's strategy to abandon its claim to any damages and accept a cross-license on terms which will not give a FRAND value to the patent in suit, EP 649. In their skeleton argument, paragraph 24, so that's core bundle, tab 4, page 54, Ericsson appears to misunderstand the point here. A supra-FRAND deal in Ericsson's favour will cover, because it's a cross-license, EP649, and we say, therefore, fail to ascribe FRAND value to that patent, as well as the rest of the Lenovo portfolio. This first point is quite independent of any issues as to the nature of the losses that may be included here, quite independent of any argument there may be as to what losses may be considered as caused by the infringement. It goes to the value to be obtained in relation to this patent under a SEP license. Now, Ericsson does have an answer to this. It's in paragraph 25 of their skeleton argument. And it is that the question which the court has to consider under American Sign Amid is whether the claimant can be adequately compensated in damages in respect of loss caused by the alleged infringement if it succeeds at trial in establishing its right to relief. So the difference between the parties here is that Ericsson's proposition is that the American Sign Amid guidelines assume there will be a trial even in those cases where the complaint is that the defendant will be unlawfully coerced, sorry, the other party will be unlawfully coerced into abandoning the trial. No authority for this proposition is advanced, and we would say it is manifestly contrary to any proper sense of justice. Mindful of the time, I might simply refer my lords to one passage in relation to this, and it's in the judgment of Lord Justice Underhill in the A, B, and CD case, which is in the Joint Authorities Bundle 2 behind tab 4 at page 402. The part of the judgment which I wish to draw attention to is at 486, paragraphs 14 to 15. My lords are no doubt familiar both with the case and with the cases referred to there. I draw in particular attention to what is stated in the observations of Lord Justice Sachs in the Evans, Marshall and Batola case set out at paragraph 15. The standard question in relation to the grant of an injunction, are damages an adequate remedy, might perhaps, in the light of the authorities of recent years, be rewritten. Is it just in all the circumstances that a plaintiff should be confined to his remedy in damages? I don't, at this stage, need to go nearly as far as reframing the proposition in that way. All I need to do is to satisfy my lords that it is proper in a case in which the complaint is that a party will be deprived of the benefit of a court determination to have regard to the loss which will flow from its being deprived of the benefit of that determination. And we may ask rhetorically would it be just for a claimant to be confined to his remedy in damages in a case where his complaint is that he will be coerced into abandoning that same claim? Ericsson also has a point on the facts. It concerns...
So you say there, the complaint is he will be coerced into abandoning that same claim. Where is the evidence that your clients will be coerced into abandoning their claim in these proceedings?
My Lord is anticipating the next point to which I was going to come, and indeed it's a point taken by Ericsson in paragraphs, I think, 26 to 28 of their skeleton argument, where they contend that there is no serious risk that Ericsson's strategy will have the desired effect. And there are two answers to this. First, we say that it's based on a misreading of Ms. Dagg's evidence, in particular, misreading of what she says at DAG 5, paragraph 9. And for these purposes, I should perhaps first of all take my Lords to her first witness statement, which is in the supplemental bundle behind tab 6. The relevant section, passage being in paragraph 29.4.1 on page 92. If interim relief is not granted, there is a serious risk that the parties will never get to a trial of the UK infringement claim. That's because Lenovo will be forced into accepting super FRAND rates as a result of Ericsson's actions. In other words, Lenovo will be forced into an unfavourable deal, obviating the need for the claim as the price for not being shut out of the Colombian and Brazilian market.
So that was said on the 12th of February 2024, but it hasn't happened yet.
Lord, if it had happened, we wouldn't be here. Because if there is an agreement between the parties, it will almost certainly involve the settlement of outstanding claims. We're not going to get into a situation in which Ericsson sets a price of $1 trillion and then we have a claim in these proceedings going on for the next few years to work out what the difference between that price and the FRAND price would be. So, of course it hasn't happened, my Lord. It hasn't happened, otherwise we wouldn't be here. What's picked up by my learned friends is the language that's actually used in paragraph 9 of Ms. Dagg's fifth witness statement, and I should just take my Lords to that. That's at the supplemental bundle tab 8, page 116. And what she says there is that one can ask, why would Lenovo persevere with litigation once it is enjoined in 2 of its important markets? The answer is evident. It is because the rates on the table from Ericsson would cause significantly more damage than the short-term pain which is being inflicted in those jurisdictions. Ms. Dagg has not corrected her first witness statement, and we would say that her fifth witness statement, and in particular paragraph 9, is plainly concerned to explore why Lenovo is persevering for now. It is already suffering serious disruption to its business and consequently serious loss. There is no way that what she's saying there should be interpreted, can be fairly interpreted to mean that the risk that Lenovo will be obliged to bow to the coercive pressure to which it's subject has fallen away. And indeed, it is not a position that Ericsson can, if one thinks about it, sensibly advance. On any view, Ericsson is going to considerable lengths to disrupt Lenovo's business in Brazil and Colombia and the United States. On the evidence of Mr. Foster, it is doing this to incentivize Lenovo to accept a license on the terms which Ericsson is offering. If Ericsson sincerely believes there is no serious risk that its doing so will incentivize Lenovo to accept a license on those terms, it's hard to understand why it's bothering itself to go to the trouble of causing Lenovo such injury. If Ericsson sincerely believes there is no serious risk that Lenovo will agree such a license, it can have no motive for disrupting Lenovo's business other than malice. So I can't say in answer to my Lord or Justice Arnold that Ericsson will inevitably succeed in what it is doing, but I can say that on the evidence that there is a serious risk that it will do so unless by this means or potentially some other we are able to obtain an order which will force Ericsson to follow a different path. Now, Lord, in her judgment at paragraph 34, we're at CB 4 bundled, tab 7, page 78. The judge says, in a FRAND case of the present type, if the patent is infringed and the parties are not competitors, the patentee's loss can normally be quantified as the sum which the patentee would have earned under the FRAND license. She refers to the unwired planet case.
Yeah, I don't understand that. It doesn't seem to have been in dispute between the parties, but it seems to me to be wrong. And the passage cited doesn't support it. Because, as one would expect, what Mr. Justice Burse actually said in that case is that in circumstances where the court has determined the terms of the FRAND license, if those terms are accepted, then the license will be retrospective and there will be no infringement. Therefore, there will be no question of any damages at all. What he is addressing, as he makes clear, is what happens if once the court has determined the terms of a FRAND license, those terms are not accepted.
I think the reason she has put it that way as to identify the rate to which we would be entitled to assess the damages in relation to the particular infringement, focusing on the infringement in this country in an entirely narrow and conventional way. And she's saying that the rate that you would pay, the damages would be calculated by reference to the user principle. So we're in some general tire territory, either in category 2 or category 3, and that applying the user principle, the rate would be the rate
Yes, but
under
we
the
don't get
FRAND
into-
license.
The whole point about this is we don't get into the user principle at all. Because we have to assume for these purposes, we focus on E 649, we assume that it's valid, essential and infringed absence of license. That's your case. The court determines what the FRAND terms for the license are. Now, at the moment, I see no basis for thinking that Ericsson will decline to accept those terms and suffer the consequence of being excluded from the UK market. And there's no evidence from your side suggesting that that is likely to be the case. So therefore, the presumption is that Ericsson will take the license on the terms determined to be FRAND. And in the circumstances of this case, as is common ground, that will in fact be a cross license, but we ignore that for present purposes. But it follows that the financial remedy to which your clients will be entitled is royalties. There will never have been any infringement and there will never be any damages.
Lord, if it is the case that the proceedings are allowed to run their course, and if what is determined is a license under which past practice of the patent is retrospectively licensed, as opposed to dealt with, as is commonly the case, in another way, such as with a clause dealing with non-assertion. And if Ericsson
Well, I'm sorry
accepts
to
that,
interrupt you, but the question of how far back the license goes is another matter. I mean, as I'm sure you're aware, we dealt with that in the Digital and Over.
yeah,
But it doesn't matter. That debate doesn't matter for present purposes, because the one thing that for sure it will cover is the period of the proceedings.
well, it is likely to cover the period of proceedings. I would accept that. But what I'm struggling with is the implications or the significance which my Lord apparently attaches to this analysis. At this stage, I'm approaching the way in which the judge has dealt with the nature of the loss that we will suffer. And I am seeking to submit that however narrowly one identifies that loss, there are circumstances in which we will be unable to recover it, recover any damages in respect of it.
To be sure, it doesn't impact on your argument that you will be deprived of the court-determined rate,
Yes.
because that's true whether the correct jurisprudential analysis is that if you got to court, what you would get would be royalties, or whether it is if you got to court, what you would get would be damages. It's
My
true
Lord,
either way.
precisely. So for the purposes of my current argument, that's not the error in the judge's approach that I focus on. It may be that that error is compounded in the way that my Lord Justice Arnold has identified. But for my purposes, the critical thing is, whether it's damages or royalties, we will be deprived of them on any view if we're obliged to enter into an agreement which does not give fair value there as a result of the coercion to which we're subject and not getting to a hearing. So if that is right, and if we simply need in a formalistic way to establish a head of damage here, for which we will not be adequately compensated, this one is on any view, without any broader considerations of causation or the nexus between the loss which we suffer and the particular infringement, one which we are entitled to rely upon. And it is a view which, whether it's treated as damage or lost royalty, is based on the commercial value of the right infringed, which we are being here deprived of. Now, Lords, I'm minded to take the grounds in the order which my learned friends have taken them. So that takes me then to ground 1 sub 4. And there we're concerned with the judge's conclusion that the only recoverable loss suffered by Lenovo as a result of Ericsson's infringement of EP 649 is the loss of the, as we might now put it, licensing revenue. We say no, we are also losing the value of the patent as a means of establishing a level playing field, as a deterrent to be used against holders of portfolios in the same space who might act in the way in which Ericsson is seeking to act. Now, it's said that this isn't an argument that we ran below. In fact, I'll just cite it. I'm not asking the Lord to go to it. We said in our first skeleton, paragraph 70, in the supplemental bundle 2 at 32, there's nothing illegitimate in our asserting our patents defensively, as Lenovo is seeking to do here. What Ericsson contends is that this is somehow a circular or a bootstrap argument. There's nothing circular about pointing out the value of shows of action, that it may depend on one's being able to assert and, where necessary, threaten to assert it. Ericsson is employing its patents in Brazil and Colombia to obtain a negotiating advantage. The ability to use its patents in this way is part of their value viewed as assets. And it is neither circular nor bootstrapping to point out that in global industry, if foreign patents are more readily enforceable than UK ones, the value of the UK patents is likely to be considered less than the foreign ones. One of the advantages to implementers such as Lenovo of their patent portfolios is that they enable such implementers to establish a level playing field in dealing with patentees such as Ericsson. This essential aspect of the value of holding a patent portfolio depends on the willingness of the court to recognize and grant relief in appropriate circumstances. And we say that just as the value of the patent will be lost in circumstances where the court is unwilling to protect it, so being able to practice the patent with impunity, as Ericsson is seeking to do, will damage the value of the patent, or be a loss to the value of the patent as owned by Lenovo and potentially available to use as a deterrent. I should make clear that Lenovo does not contend that a notional royalty could never capture the loss of the value resulting from the inability to deploy the possibility of seeking an interim injunction to deter a negotiating party from seeking or enforcing such relief against a step owner. That raises a question about what aspects of the bargaining position of a party may be taken into account when calculating and negotiating damages, whether under the principles as explained by Lord Reed in the one-step case, or indeed more specifically dealt with by Lord Justice Arnold in the Formula One case. But we're not really in that territory here, because the principal threat is that we'll never get to a judgment. So the question of what damages we might be entitled to if we got there is, or at least there's a serious risk, it will prove to be sadly academic. Now, the judge held that it is not seriously arguable that Ericsson's infringement of EP 649 will be found to be a cause of the loss which Lenovo is seeking to avert. And of course we dispute that. The starting point of any causal analysis is that there's an arguable case that the infringement is an essential element of Ericsson's strategy. In other words, that there is but-for causation in the sense that the loss would not occur in a world in which there was no infringement. I appreciate that but-for can also be used to refer solely to those necessary circumstances to which we give a causal status, and I think it's used in that way, for example, in the Anand Kazai and Neochemicals case. However, we are not using it in that way. We're using but-for in the sense in which it is held in the authorities may not be sufficient to give causal status. Lenovo contends that there is at least but-for causation because, one, the commercial benefit of Ericsson of continuing to supply 5G compliant goods and services in the UK is part of the strategy to establish a commercial advantage vis-a-vis Lenovo. And faced with a choice between abandoning its 5G market in the United Kingdom and abandoning its strategy, Ericsson will likely choose the latter. Ericsson, we say, does not attempt to refute this. It is at the very least arguable that Ericsson will not pursue its strategy in Brazil, Colombia, or elsewhere if there were to be no commercial advantage to its so doing. Now, of course, the but-for causation is not the end of the inquiry. The nature of the inquiry we find adverted to, I suppose, the most celebrated passage in the speech of Lord Nichols of Birkenhead, which is cited in, among other places, in the judgment of Mr. Justice Peirce, as he then was, in the Convatec case. And it might just be convenient to refer to that passage for reference before I develop the submission further. That's in Joint Authorities Bundle 2 at tab 13, page 470. And the relevant passage is at page 478 paragraph 39, which also conveniently refers there to the judgment of this court in the Coflexit and Stolt offshore case. At paragraph 71 of Lord Nichols' speech in Kuwait Airways, he states, "In most cases, how far the responsibility of the defendant ought fairly to extend evokes an immediate intuitive response. This is informed common sense by another name. Usually there is no difficulty in selecting from the sequence of events leading to the plaintiff's loss the happening which would be regarded as the cause of the loss for the purpose of allocating responsibility. In other cases, when the outcome of the second inquiry is not obvious, it is of crucial importance to identify the purpose of the relevant cause of action and the nature and scope of the defendant's obligation in the particular circumstances."
It may not matter, but of course a lot of water has flowed under the bridge, not least from the Supreme Court itself since then.
Lord, I don't believe it will matter for these purposes, especially bearing in mind that all I may be required to do for these purposes is establish that there is a serious argument as to whether or not we can establish or will establish at trial a causal nexus. Of course, that being the issue in particular in the Coflexit case, which led to the pleading in that case being reworked but not struck out. And whilst I fully accept, of course, that much water has flowed under the bridge since then, this is one of the key passages which has been referred to in many of the cases following it, and it identifies two key threads which we would maintain remain good law. First of all, the application of common sense, which is what the judge considered that she was applying in rejecting our arguments. And secondly, the notion of attribution of responsibility tempered with a consideration of purpose. So as far as common sense is concerned, that's of course a much criticised yardstick. What counts as a cause as a matter of common sense may be value-laden, it may be fact-specific. The key point to be recognised here is that determining which of the sequence of events is to be treated as a matter of common sense, as the cause, requires one to look at all of those events and understand the role that they play in the outcome. But it's not simply are they necessary, that's the but-for test. It also involves an attribution of responsibility. And in a case in which both parties may ultimately require a license, but there's an obvious advantage in being free to operate without a license for longer than one's counterparty, being able to infringe with impunity in circumstances where the counterparty is suffering disruption may be the key to obtaining that advantage. And that is a factor which may be identified as one of the necessary factors of the mischief complained of, to which it is appropriate to attribute a causal status. It's true there are two pillars to Ericsson's strategy. First, that it can practice Lenovo's patents without negotiating for the right to do so. And second, that it can stop Lenovo practicing its patents unless Lenovo accepts the terms which Ericsson is offering it. However, we say, as a matter of common sense, that the infringement of Lenovo's patents is not just a condition of Ericsson's causing Lenovo the loss that will result from its being forced into a super FRAND license. It is one of the very pillars of that strategy, and it is deliberate. Now, the judge explains what she saw as the disconnect between the order that Lenovo is seeking and the alleged loss which it may suffer in her judgment of paragraph 40. And we submit that she's misunderstood there what the real relationship is. One goes to the core bundle tab 7, page 79. She states there the disconnect between the alleged infringement and the loss relied on by Lenovo can be illustrated in this way. If Ericsson were to be enjoined by this court in the manner sought in paragraph 1 of the draft order, that would not have any impact whatsoever on the proceedings in Brazil and Colombia, or any injunction granted in those jurisdictions. Critically, she considers the order as set out in paragraph 1 without the proviso. Secondly, her statement that a UK injunction would have no impact on the proceedings in Brazil and Colombia ignores the fact that the absence of a UK injunction is an essential part of the rationale for Ericsson's pursuing the interim injunctions in Brazil and Colombia. That it's simply factually wrong. Thirdly, she fails to consider that the interim injunctions in Brazil and Colombia are not a sufficient cause of Lenovo's loss of bargaining position. She fails to consider Lenovo's loss of bargaining position depends on Ericsson being able to impose a different interim regime on Lenovo to the regime that Lenovo is able to impose on Ericsson. So we would submit it is at least seriously arguable that as an essential and deliberate element of Ericsson's strategy to obtain a competitive advantage over Lenovo, Ericsson's ability to practice EP 649 without a license is a cause of its obtaining that advantage. I come then to the third element of ground 1, where we have the point that we have just emphasized in relation to the issue of causation is that the loss suffered by Lenovo as a result of Ericsson's strategy is not only foreseeable, but it's intentional. And we've seen that it chimes with the evidence of Mr. Foster as to what it is that Ericsson is seeking to achieve by creating this asymmetric bargaining position. And without recapping unduly, we acknowledge it may be appropriate for a set owner to deploy such tactics when the implementer is unwilling to enter into a license, but submit that once the implementer has committed to enter into a license, in this case, offering for that to be determined either in this court or in the EDNC, there is no legitimate justification justification for such incentivization. So, if insofar as any policy question arises, in any issue of, as it were, remoteness, we would say that it is at least seriously arguable that the damage that we have identified is not too remote and should not be excluded from recoverability as a matter of policy. I think I've already dealt with the, albeit perhaps quite briefly, with the different ways in which a running royalty might be calculated. It is, though, perhaps of assistance here, because if one's asking whether or not the loss, which we say is caused, should be treated as caused by the infringement, it may be of assistance to ask, well, is that something which it would be legitimate for a SEP owner to take into account when negotiating a notional user license to permit such activity. And of course, we are concerned here with the contrast between infringement and either not practicing the patent or, critically, only practicing it with permission. The learned judge, we'll see, has focused on a situation in which Ericsson simply ceases to operate. But when one is negotiating user damages, one's considering what the price would be for the grant of permission. Because the monopoly that one has in a patent gives you the right either to exclude or to charge a price for one's consent. And if one looks at what may be taken into account by the, when calculating user damages, I think I should take, my lords, at this stage briefly to a passage from the judgment, my Lord Justice Arnold, in the Force India case at Joint Authorities Bundle 1, Tab 11.
Mr. Locke, I'm sure you are keeping an eye on the time, but you're becoming a bit concerned, because we're only on ground one.
My Lord, yes. I anticipate, with my Lord's permission, that I will not have finished my submissions by 1, but should require no more than 20 minutes after lunch.
That doesn't give Mr. Tappan a lot of time.
It doesn't.
I will endeavour to speed up then.
Please. You're going to take us to that or not?
Well,
Or just refer us?
I can simply refer, my Lords, to it. So
Yes.
the case is at Joint Authorities Bundle 1, Tab 11, page 354.
Yes.
The critical point is that one's concerned with
Which
the price
paragraph?
of permission, the relevant
Sorry, paragraph.
paragraph 386.
Thank you.
I'm concerned with the price of permission, and what one has to do is have regard to the position and bargaining position of the actual parties. So, in this case, Ericsson is coming to Lenovo and saying, how much are you going to charge me for continuing to practice your patents in this country, while I am seeking to obtain a negotiating advantage at your expense by enjoining your activities abroad. And our submission is that the reasonable party in the position of Lenovo, and taking account of Lenovo's negotiating position, can say the price that I set will have regard to your activities abroad. The condition for my giving permission is either that you cease those activities and accept the price that flows, or that you will pay me a higher price reflective of the negotiating advantage that you have obtained at, or are seeking to obtain at my expense. And if that's right, and we say that it is at least arguably so, then it would be very surprising if those same damages couldn't be taken into account when considering whether or not the loss, that same loss could not be taken into account when considering what was and was not caused by the infringement. Lord, I come then to ground 2. The judge notes that paragraph 45 that Lenovo conceded that the loss that Ericsson would suffer if it ceased to sell 5G compliant goods and services in the UK rather than desist in its strategy would not be adequately compensated in damages. However, the judge did not address the question of whether there was a serious likelihood of such damages arising. The judge simply recorded paragraph 45, which is that Core Bundle 7, page 80, the concession that Lenovo made. What we say is, on the logic of Ericsson's own evidence, there was no serious likelihood of such damage arising. The harm Ericsson's witnesses contend that Ericsson UK network that Ericsson and the UK network providers, and indeed the UK public, would suffer is such that there could be no realistic prospect of Ericsson choosing to abandon the UK rather than abandon what we say is its unlawful and inappropriate strategy against Lenovo. So if the order is granted, Ericsson, we say, is bound to use the proviso to avoid such harm. This is addressed by Ericsson in paragraphs 42 to 47 of their skeleton argument, but when one views it carefully, it may be seen that they don't actually dispute that, as a matter of fact, if the order is made, they will take advantage of the proviso. Ericsson in paragraph 42 refers to the undisputed fact that it would suffer a serious loss if it withdrew from the market. In paragraph 43 it says essentially the same thing. In paragraph 44 it notes that Lenovo contends that it will not choose to incur this loss. It neither confirms nor denies it. And in paragraphs 45 to 47, it raises questions of law, which we have or will address separately. The simple fact is that there is no denial of the fact. What Ericsson purports to do is to articulate a general principle, and one sees that at 45. It says it is wrong in principle to make an order which would cause very significant damage to Ericsson in order to force Ericsson to do something which Lenovo has not sought the court to order. Now, this, we say, is wrong. Leaving aside the rhetorical flourishes, and it's a matter which I dealt with in answering questions earlier. It is inherent in any FRAND order where there is on the one hand an injunction, on the other a proviso, that the order may influence a party to act under the proviso, and it will commonly be the case that it is the acting under the proviso that it is of that is desired by the claimant. So we say that the principle there is not a sound one. At 47 of their skeleton argument, Ericsson argues the correct question is whether the balance of convenience lies in favour of preventing Ericsson from selling 5G compliant equipment in the UK pending trial of the claim relating to validity and infringement. In other words, does the irreparable harm to Ericsson arising from such an order outweigh the irreparable harm to Lenovo? There are, we say, two potential reasons why Ericsson may be saying this. First, because one should always disregard the impact of a proviso, and that we say is wrong in principle. And secondly, because the proviso in this case is inappropriate. But the proviso in this case, we say, is entirely appropriate, and one which has not been in itself significantly criticised. The only criticism that's made, and I'll allow my learned friends to develop it in the light of the time, is that it is somehow unclear, and that if the court is minded to grant us an order, it needs to be in clearer terms. I'll let my learned friend develop that argument, but we will, if necessary, submit that it is extremely clear what it is we are seeking to achieve, and if there's a variation to the wording that's required, they may identify it. One comes then to broader considerations as to the balance of convenience or the balance of justice. And in relation to that, it would appear, and I'm not sure that a great deal hangs on it, because she didn't actually get to an assessment of the balance of convenience, it would appear that the judge has taken a extremely narrow view of the matter, and in that regard, I just refer to paragraph 30 of her judgment, and her citation there of the principle that she derives from the Bremer Vulcan and South India shipping case. That's paragraph 30 of the judgment at Court Bundle 7, page 77. I say that not a great deal hangs on it because, of course, she has not actually conducted a assessment of the balance of convenience, but just for purposes of my Lord's note, the Bremer Vulcan case is one of those specifically considered in the judgment of Lord Leggett, with whom Lords Briggs, Lord Sales and Lord Hampden agreed in the broad idea case. The relevant passages I can give you for your note, paragraphs 52 and 53 in the Joint Authorities Bundle 2, tab 20 at 730. Plainly, we have moved on from Susquehanna, Bremer Vulcan, and in that interpretation, American Sinomid 2. As regards the general principles to be followed in relation to the application of the American Simon test and its being guidelines and no fetter on the application of section 37(1) in accordance with justice properly understood in cases such as South Carolina, Bacterterm and Channel Tunnel. We cite the judgment in the Wolverhampton case, the judgment of Lord Reed at paragraph 16 to 21, which is in the Joint Authorities Bundle 4 behind tab 26 at pages 1352 to 1353, in which, amongst other citations from the cases that I've referred to, and indeed from Thury and LaRue in the speech of Lord Scott of Foscott in that case, they cite the observations of Lord Nichols of Birkenhead in Mercedes Benz and Ledak. As circumstances in the world change, so must the situations in which the court may properly exercise their jurisdiction to grant injunctions. The exercise of the jurisdiction must be principled, but the criterion is injustice. Injustice to be viewed and decided in the light of today's conditions and standards, not those of
Yeah, well, I see
yesteryear.
the key point you're making is that it is no longer the law that an injunction is only granted for the enforcement or protection of some legal or equitable right. And the example which I'm fond of trotting out, which I'm sure you'll be very familiar with, is the website blocking injunction cases, where injunctions are granted explicitly against persons who have done no legal or equitable wrong. And that was endorsed by the Supreme Court in the Cartier case and formed part of the foundation for the subsequent reasoning in Broad Idea and Wolverhampton. So, the judge's statement, based on Bremer-Balkan, is an error, but why does it matter?
My Lord, there's a sense in which it may not matter because she expressly states that she doesn't go on to consider anything beyond the question of whether damages will be an adequate remedy, and therefore once one does get beyond any such narrow inquiry, it will be for my lords to exercise your own discretion. I have identified the relevant paragraphs, in part because it is, we submit, indicative of the approach that she also took more generally to the question of damages, in part because it was, as I understood it, or may be taken against me, and thirdly, as a means of structuring my submissions in relation to these issues. But fundamentally, it is a mistake that does not matter. The broad outline of the jurisdiction, using that term somewhat ambiguously, is, we submit, clear. As Lord Scott puts it, jurisdiction in the sense of power is not in question. What we're concerned with here is jurisdiction in the sense of proper practice. What we got from the quote to which I just
Well, indeed, I mean, rather than practice, I would prefer to use the word principle. So what you need is a principled basis for the exercise of the jurisdiction. And the question, therefore, I would ask is this: what is the principle you are invoking?
The principle that we are invoking, but let me step back if I may, my Lord. The overriding principle here is whether it is just that we should be left to our remedy in damages. The question is, how does one focus on the particular fact patterns in which it will be just and distinguish those from the fact patterns in which it may not be just. So I think the principle is being used here in the sense of what are the factors that will warrant treating the granting of an order as just or a granting of an order as not just. And we would also accept that when identifying those patterns, one is looking for ways of generalizing them so that we do not get into a situation in which each individual case is considered on its own merits, and the court is, in the sense in which I believe my Lord Justice Arnold was using it, acting unprincipally but on intuition. So what are the facts on which elements of this fact pattern which we say warrants intervention? First, that there is a serious risk that we will suffer a loss which we will not be adequately compensated in damages because we'll never get to a hearing. Secondly, there is a serious risk that we will suffer a loss which we will not be compensated in damages because the nature of the loss, while closely connected to the mischief of which we complain and avertible by an order, is not one in respect of which the court will award damages. There one gets into the area of uncertainty as to how damages might in theory be calculated. Thirdly, that an injunction being in its nature an equitable remedy, albeit one that is now founded in statute, rightly focuses on the conduct of the person to whom the order is directed. I'm thinking there of the judgment of Lord Justice Mance in the Moylan case. And if one looks at the conduct of Ericsson in this case, it is one, at least seriously arguable, that it is in breach of the undertaking that it gave to ETSI and to implementers such as Lenovo. Two, it is of a kind which is calculated to disrupt the market, to disrupt proceedings, and has been deprecated by the judges in this court. And I'm not sure which number I've got to, but whichever one it is the next. It can fairly be characterized as unconscionable, given not only that it is being done in breach of the ETSI undertaking, but because it is directed to drive us from a court determination. And if I'm thinking about the origin of the foundation for different forms of injunction, for example, I think it's in the Mercedes-Benz and Lida case that Lord Nichols of Birkenhead explains the Morava jurisdiction by reference to the court's anticipation of giving judgment and the preservation and protection of the efficacy of that judgment. One reason why the courts do award grant injunctions is to preserve the efficacy of their judicial process. And what is being done in this case is directed to depriving us of the benefit of that process. And then finally, and viewing the matter not simply from the perspective of the parties, but having a wider regard to the public interest and the proper operation of standards regimes such as that imposed by ETSI, we would say there is an important value in discouraging parties from disrupting the judicial determination of license terms. There is inherent in the ETSI policy itself and in the approval of the regime by the Supreme Court a value to be attributed to the smooth operation of the market, and in that context a need for parties to negotiate fairly and reasonably, which this order is calculated to encourage, rather than resort to the sort of strategies which it is directed to avoid. Lord, mindful of the time and my Lord's indication, are there any matters which I should have dealt with at this stage which I have failed to?
You haven't explicitly dealt, although you covered much of the ground 4. Is there anything you want to add on ground 4?
Ground 4 is simply addressing the charge that the order we're seeking has a anti-suit character to it in the pejorative sense, or the sense that it is a threat to comity. And I think I have made 2 at least, if not all 3 of the principal points that I would make in relation to that. First is as to the form of the order itself, which is in no way preventing or prohibiting actions in any other jurisdiction or advising any foreign court as to the law. Secondly, as to the fact that insofar as it seeks to influence a party in relation to the conduct of proceedings abroad, it is doing something which is not inherently wrongful and in fact very much in line with a standard FRAND proviso order. Thirdly, that whilst it is true that an anti-suit may be an alternative way of proceeding in some cases, it does not mean that we can't proceed to the same effect, if insofar as it is fairly characterized to the same effect, which of course we dispute, if we have a proper alternative basis, and that is in no way surprising, given that insofar as the anti-suit in its classic form is justified by principles of unconscionability, principles of unconscionability will also provide grounds on which the court may be moved to make orders which are framed by way of foundation in another way. And then finally, there is in fact a point of comparison which can quite usefully be made with an anti-suit. I mean, an anti-suit is an order which, at least in its classic form, will prohibit a party from pursuing proceedings abroad. If that is something which may be fairly regarded as unconscionable, one can compare that objective with the objective that of Ericsson's strategy in this case. There is a certain irony in Ericsson's complaining that we would be seeking to put pressure on them to cease proceedings abroad. And of course, that's precisely what they are seeking to do in relation to the proceedings in this country. And finally then, one last observation in relation to the suggestion that what we're doing is, as it were, tit for tat. What matters, we submit, is the circumstances in which we are seeking this order and the purpose for which we are seeking it. We are seeking it because we are the subject of a coercive attack, and we are seeking it to obtain a level playing field and enable this court to decide the dispute between the parties. If you ignore that, yes, we're seeking an injunction when they've got injunctions. But we would submit it is wholly inappropriate to ignore that.
Anything else? No, thank you very much.
Thank you.
And we'll start again at 2 o'clock. How long do you think your submissions will take?
Well, to some extent I'm in my Lord's hands, but
Of course.
depending how many questions are asked. But I
course.
don't actually think I will be that long. But my predictions are usually wrong in these regards.
Thank you very much. So 2 o'clock.
Ryan.